Hi everyone. This is going to be a quick hitter. I know the bar exam is fast approaching. I want to talk about a few more issues in this series of short videos, and post one more outline and very short template in this case. I'm going to talk in this video about due process and equal protection. Frankly, I'd expect more multiple choice questions about these issues than essay questions because, as we've discussed before, the bar examiners like to test standards of review in their multiple choice questions. And so, as you'll see here, as we go through this, that's what these areas of law are mostly about. As to due process, remember there are two kinds. There is a procedural due process and there's substantive due process. So let's talk procedural first. Procedural due process question arises in terms of spotting the issue when somebody is claiming fundamentally that the government took something away from them, whether it's their life, their freedom, or something they possess, they own, without being fair. So you really have to wrap your mind around these concepts in order to spot the issues. Right. I'm not saying when I'm raising a procedural due process claim, I'm not saying I had a fundamental right to do something. I'm saying the government did something to me that wasn't fair. In terms of process, right? That's the name, process and procedural. When you see a claim like that, the first thing you want to check is whether there is, and I don't have everything on this outline, some of it I'm just going to talk through. But the first thing you'd want to check is whether there is a liberty or property interest at stake in the fact pattern. Here, watch out for things like harm to reputation. A court could say if that's all you've got, that's not even a valid property or liberty interest. The other thing you want to really watch out for would be the possibility that the government has fired somebody. See, this fits into the fact pattern, right? You did something to me that was bad and it wasn't fair. So when the government fires somebody, you want to check, did that person have a contract that entitled that person to continued employment? Did the person have tenure, right? Because if all the person had was a unilateral expectation of continued employment, in other words, at will employment, that doesn't count as a property interest. So the first thing you got to do when somebody says the government wasn't fair to me is, was there something concrete that the government did to you or took away from you? Once you've got past that, then you would, so you assume that there is a procedural due process claim to begin with, then you look for the three basics, which are notice, hearing, and impartial decision maker. IDM here stands for impartial decision maker. I would spend time checking for each one of those. Did the government tell me what the rules were? Did the government tell me that I violated the rules? That's notice, right? When did the government tell me? Well, we'll get to that in a second. But check that it even exists, right? Did I get notice? Check for a chance to tell my side of the story. Opportunity to be heard are the magic words. That's the definition of a hearing. So you would check in the fact pattern and see, did the person have a chance to say, I didn't do it? And finally, impartial decision maker, which means somebody with no stake in the outcome, no bias or prejudice. Now, if those three things exist, and those are the three elements, if you will, of procedural due process, then you would look to whether the procedures were adequate. Okay, whether they exist is one question. Whether they were adequate is another one. When you get to the question whether there was enough due process, then you apply the Eldridge factors. And these are factors that some people would call this balancing, because you look at them in relation to one another. I think that would be fine to say on a bar exam. How much process you get and when depends on, first of all, the importance of the interest that's at stake. That's common sense. Second of all, the risk of erroneous deprivation, as the courts say. So the risk of the government making a mistake using current procedures, right? How dangerous, essentially, is it for the government to use the current procedures that it's using? And finally, you would consider what are the costs associated with implementing, using whatever procedures you're suggesting or asking for as replacement procedures. Now, substantive due process is a different animal. That's not the claim that the government wasn't fair to me when it did something bad or took something away. It's the claim that the government's interfering with a right that I have that's just simply none of the government's business at all. Now, again, on a bar exam, they're not going to ask you questions as nuanced as we ask you in law school. Not going to test you on some kind of new fundamental right, whether a right should be fundamental. And in all likelihood, If you have a bar exam question on this, they're going to be throwing rights at you that are already, the court has decided, either are fundamental or are not. As to rights that are not fundamental, some that come immediately to mind, all economic rights are low-level rights, so you would apply rational basis in those cases. A physician-assisted suicide is not a fundamental right. The right of unrelated persons to cohabitate, not a fundamental right. Those types of things come immediately to mind. The Supreme Court has already ruled on those things. I think more importantly, the list of rights that the court has said are fundamental. Substantive due process rights. So I should make that clear. Substantive due process is the body of law dealing with fundamental unenumerated rights. I'll get to the text here in a minute, but let's talk nuts and bolts. If you see a fact pattern where the government is substantially interfering with one of these rights, marriage, marital privacy, procreation, contraception, right, access to contraceptives, the 3 C's, care, custody, and control of children, or family living arrangements. When the government interferes in one of those areas, substantially interferes in one of those areas, you're going to apply strict scrutiny. You know what that is by now. So this is just meant to be a review. If you're just learning strict scrutiny now, it's too late. Okay. Now, this part of the handout that's attached in the description below, by the way, the link is there. I'm going to talk substantive due process and also equal protection, because I want to talk about, in these types of cases, when strict scrutiny applies and sort of lump it together that way. So strict scrutiny applies under substantive due process principles when the government substantially interferes with the exercise of a fundamental right. As you know, strict scrutiny also applies in equal protection cases when the government discriminates against a suspect classification. Those classifications being race and ethnicity, alienage, and sometimes religion. I say sometimes because oftentimes courts deal with religion under the religion clauses of the First Amendment. You know your exceptions. I put a little parenthetical here for next to alienage. You have to know your exceptions. Obviously, when Congress regulates immigration and naturalization, that only gets rational basis review. And also when a state excludes non-citizens from performing governmental functions, that would get only rational basis review. So I'm not going to get into detail about those. You just need to keep those in mind. Hopefully you've studied those and you know what I'm talking about. Intermediate scrutiny, on the other hand, applies only really in equal protection cases. And you have to apply intermediate scrutiny when you see discrimination against gender, people born out of wedlock. The word courts used to use would be illegitimacy. I'm not sure I'd use that word on a bar exam. I think I'd say children of unwed parents or people born out of wedlock. Also remember that undocumented immigrants, people who are not here legally, are not a suspect classification, although alienage is, right? Undocumented immigrants are not. However, the children, when the government discriminates against the children of undocumented immigrants, courts apply intermediate scrutiny. So please keep that in mind as well. I've got a couple notes here following this brief outline of substantive due process and equal protection. Again, I'm just trying to get an outline in your heads of macro issues, big things to be watching out for, not to miss. First of all, under the Equal Protection Clause, don't forget that sometimes a law does not discriminate on its face, but discriminates as applied. So whenever you see statistics in a fact pattern that there is a disparate impact, right, a disproportionate impact on people, essentially, let's talk the most common, right? It's either going to be ethnicity or gender. When you see some kind of disproportionate impact on people who are ethnic minorities or who are women or who are men, when you see that kind of thing, you're then going to have to look into the fact pattern to see if you see evidence of intent, right? Because the two elements of a successful as applied attack under the Equal Protection Clause are disparate impact and intent. So if you find under an as applied approach that a law isn't purposefully discriminates against people on the basis of ethnicity, you would apply strict scrutiny. If you find that a law purposefully discriminates against gender, then you would apply intermediate scrutiny. Also, don't leave one of these questions without citing text. you have to know what text applies to what government and how. So the 14th Amendment on its face applies to states, but it applies to the federal government through the Fifth Amendment Due Process Clause. As to the Due Process Clause, what clause is, there are two. The Fifth Amendment Due Process Clause applies to the federal government, and the 14th Amendment Due Process Clause applies to the states. So some quick templates depending on what level of review you're applying. I would absolutely memorize these and be ready to apply these very quickly. First of all, since strict scrutiny applies, assuming it does under the fact pattern, the government has the burden of persuasion. It has to show that the means are narrowly tailored to the achievement of compelling interests. So you need to be able to apply those. You need to look at what is the government trying to achieve and discuss whether that is compelling. You're talking there about health, safety, saving life, things like that. And then you would have to look at the way the government has tried to achieve the interest, how. And then you would have to decide whether that's narrowly tailored. As Lainey was just about to explain, narrowly tailored means the best possible way. So as her bark indicated, this test has some teeth. If a court can think of better ways, more reasonable ways to achieve the interest, then the law would be struck down under strict scrutiny. Intermediate scrutiny, the burden is still on the government, only now the verbiage changes with regard to the means and the ends. The means have to be substantially related to achieving an important interest. So this still has some teeth, but it's a slightly easier standard for the government to meet. So a brief review. Be ready for a due process question. Remember that due process questions come in two species, procedural or substantive. With regard to substantive due process and equal protection, the big thing is what level of scrutiny applies and how well you apply. Hope that helps. Again, good luck, stay safe, and keep us posted after the bar exam of how things went.